And then, Mr. Evora, would you like to go to the desk, or are you, whichever is easiest for you? We'll do a little change of shift there. And I will take this opportunity as well to say that that poster does exist, and that Mr. Evora, I'm sure, can tell you where to get those. I know he brought in several for me to have filled out and put throughout the State House. So very salient point and a very good idea.
Good afternoon, members of the committee. I am going to begin with a disclaimer because, as fate would have it, I had major oral surgery yesterday afternoon, so that is impacting the way that I speak. I've already had a few laughs in the office, but with that disclaimer, what I'd like to do is really just give a very quick overview of the State Commission for Human Rights, and then you have a handout which I'd like to review in detail with respect specifically to our statistics on sexual harassment. But by way of general overview, the State Commission for Human Rights is the state organization. It's part of state government, as is Ms. Burrell's organization, but we are an independent entity, and we are charged with enforcing the state's anti-discrimination laws in the areas of employment, housing, public accommodations, and credit. By far, employment cases are the bulk of the cases that we take in any given year. Probably about 75% of the cases that we take in are in the area of employment. The Commission has been around since 1949. It was created by the General Assembly back then, way before Title VII, and we consider it a feather in our cap that we are one of the oldest state agencies of our kind in the country. I would refer you to the annual report that I passed out. Page 6 has an overview, which I would just like to go through very quickly, just to give you an idea of what to expect when a charge is actually filed with us. One of the things I would point out is that in addition to enforcing state anti-discrimination laws, the Commission for Human Rights has contractual work-sharing agreements with both the EEOC and with HUD, so we do concurrent investigations of federal as well as state laws in terms of alleged violations of those laws, where we are able to co-file them if the basis is a basis that's covered both under state and federal law. But just to give you a really quick overview, because I know there were some questions about what to expect when one wants to file a charge. We, by the way, have jurisdiction over any employer within the state of Rhode Island that employs 4 or more people. That includes the state and political subdivisions of the state, but it also includes anyone who has 4 or more people. So I know that Ms. Burrell explained to you that her office has specific jurisdiction over state employees and the state as an employer. We cover the state, we cover cities, but we also cover any entity within the state that employs at least 4 individuals. So our net is really quite broad. When an individual files a charge of discrimination with our office, that starts typically with an intake questionnaire. They can access that online on our website. Individuals will walk in. We also take telephonic inquiries, and we will send an intake questionnaire to someone, or they can fill it out online and submit it to us. But a charge almost always begins with an intake questionnaire. Once we get that intake questionnaire, we have designated intake staff that will develop a charge from the information that they get. That happens probably in about, I would say, 80 to 90% of cases. The other 10 to 20% are charges that are drafted outside of the office, typically by an attorney who simply submits a notarized charge, which we would accept as a charge of discrimination. But once the charge is actually filed, and state law does require that that charge not only be signed, but that it be notarized, that someone attest to the assertions that are in that charge, we would then assign that charge to investigation. We have 7 staff members who are dedicated to investigating charges of discrimination for all charges throughout the state of Rhode Island. Overall, we have 14 employees, but 7 are dedicated specifically to investigation. Once a charge is assigned to investigation, The investigator really has a lot of latitude in terms of trying to develop a case investigative plan. They'll work with me, they'll work with our staff attorneys in terms of reading the charge on its face, looking at the position paper. We do send out letters as soon as a charge is filed with us to the respondent or respondents in the case, saying that they have a time certain within which to file a response to the charge, and that's what really gets the ball rolling in terms of our ability to formulate an investigative plan and see what types of investigations are needed, what types of investigative techniques. So, for example, if a charge is filed and it's handed over to an investigator could conduct in-person interviews. They could go on site if that's called for, depending on the allegations in the charge. They could send out what we call RFIs, or requests for information, with a time certain within which to reply. We do have subpoena power, so in those instances in which we're dealing with a recalcitrant respondent, we have the ability to issue a subpoena signed by one of our commissioners typically, and we will call them in and ask them to either provide the documentation or explain why they didn't. And there are certainly fines and penalties available within our law for those who refuse to obey the subpoena. So I want the commission to be aware of that. Ultimately, the goal of the investigator is twofold, either to settle the case or to make a recommendation to a commissioner of probable cause or no probable cause. In the past fiscal year, we were able to settle approximately 22% of the cases that we took in prior to an actual investigative finding. So we're happy with that rate. It has been higher in some past years, lower in some past years, but that's pretty much the average. Between 20 and 25% of the charges that are filed with us settle prior to an investigative finding. If settlement isn't possible in a given case, that investigator is responsible once he or she gathers what they believe to be sufficient evidence to make a recommendation one way or the other. They would write a report making a recommendation to a commissioner. It's reviewed by me before it goes on to one of our commissioners, and they would recommend either no probable cause or probable cause. And I always like to emphasize when I speak that even for those cases in which we find no probable cause, I don't think it's fair to say that that meant that there wasn't discrimination or harassment. What that meant from a legal perspective is that there wasn't sufficient evidence able to be adduced during the investigation to establish by a preponderance of the evidence that there was discrimination. I always like to emphasize that because when people look at our statistics on no probable cause, they may infer something that may legally not be appropriate. But in any event, an investigator's responsibility is to make a recommendation if they can't, again, settle the case. That would then go through me to review the report. If there are any deficiencies that I note, it goes back to the investigator to either get additional information or evidence. But once that's finalized, it goes to one of our commissioners. We have 7 commissioners who are appointed by the governor. They serve 5-year staggered terms, and only our commissioners have the legal authority to actually issue a ruling. I, as the executive director and as an attorney, don't have that authority under state law. It is only our commissioners. If a case is ruled no probable cause, that pretty much ends the case with the Commission for Human Rights. A person can move to reconsider based on new evidence or after acquired evidence, but it's very rare that those decisions are overturned because typically there isn't any additional information that a party would give to us. But they do have the right under the Administrative Procedures Act to appeal that finding of no cause directly to Superior Court, and some individuals do that. However, if there's a finding of probable cause, we enter a new phase. The case first comes to me after the parties are notified that we have found probable cause. By the way, probable cause is not a final finding. It gets the complainant over that first hurdle. It basically says during the investigation, a commissioner looked at the evidence that was gathered and said it is more likely than not. That's pretty much the standard for probable cause, that it's more likely than not that discrimination or harassment occurred, but it is not a final finding. Under state law, if we find probable cause, we have to send letters to all of the parties advising them of our finding of that commissioner's ruling and of giving them the opportunity to elect. And by that I mean state law has a specific provision in it that allows any party, after a finding of probable cause, to elect to terminate the proceedings at the Commission for Human Rights and request that we issue what's called a notice of right to sue to the complainant. Now, we have many cases in which we find probable cause and the complainant would actually prefer to stay with the commission, but the respondent elects to have the proceedings terminated, which, as I said, it is their right to do. In those cases, even against the wishes of the charging party, we have to issue that notice of right to sue, terminate our proceedings. That document goes directly to the complainant or his or her attorney, and they then have 90 days within which to file their suit in Superior Court, or they lose their rights to pursue that matter at all. For those cases that don't involve an election, in other words, there's a 20-day window after a finding of probable cause, after notice is received, within which the parties have the right to elect. If we don't receive an election, by default, that case stays with us. I then get involved in trying for a second time to conciliate the case. This is post-investigation, so there are instances where a case is with us, and there's a little more incentive for a respondent to settle a case because they now have a finding of probable cause against them. So some of those cases settle, but some of them do not. If the case does not settle, but it's on track with the Commission for Human Rights because there hasn't been an election, then that case would proceed to an administrative hearing before the Commission for Human Rights. One of our commissioners would serve as a hearing officer, and that process is much more formal than anything that's gone before. The investigatory process is pretty informal in the sense that it's what I would describe as user-friendly. We were created as an administrative agency specifically to develop expertise in that area and to be accessible to individuals. That does not mean to imply that we don't comport with due process. We certainly do. But the stakes are obviously higher after probable cause, and at an administrative hearing, it would occur in very much the same manner that you would expect a trial that you would see. There is a stenographer, there's an official record, there are objections and overrulings and what have you, but that proceeds as generally a trial would in court. If we find discrimination as a result of an administrative hearing, the Commission then has the power and the authority to award remedies, compensatory damages, back pay, any remedies that you can think of that a court would award, with one exception. We have taken the position, based on our reading of our statute, that the Commission cannot award punitive damages. We take that position specifically because it's not enumerated in the section that talks about what we can do, but it is referred to later in the FEPA, or the Fair Employment Practices Act, in talking about what a court can do. And we've taken the position that since it's not in the specific subsection that enumerates what we can do, but it is listed later, that there was a reason the General Assembly left it out. So we have taken the position that we can do anything that a court can do in terms of an award for remedies, except we cannot award punitive damages. That is a general overview of the Commission for Human Rights, and I think what I would like to do is maybe stop there, see if there are any questions about our process, and if not, then I can go into the specifics of the statistics that we were able to gather and give you specifically on sexual harassment cases.
The commissioners have questions? Yes, Mr. Palmisano.
Before a case gets to that stage, either party can request a right to sue and remove the matter to court?
Correct, after a finding of probable cause.
So what percentage of parties, if you know, opt to have a hearing before the Human Rights Commission as opposed to going to court?
Those are the statistics I'm going to get to on that handout. Okay? Hold on for one moment. Absolutely. Absolutely. Great question.
Yes, so we have the statistics. I'll go into those next. Do you have a question on the process?
Yes.
Absolutely. Representative Giarrusso.
Thank you, Madam Chairwoman. I noticed that you said that your agency covers employers of 4 or more.
Correct.
Now that's a pretty low number. I mean, why not drill it all the way down to 2? Is that a legislative act?
That would be a legislative act.
Okay,
That's
and-
language that's provided for in the Fair Employment Practices Act, absolutely.
Now, with that said, is there a parallel between the smaller employers and companies that have big numbers of employees, like as far as offenses are concerned? Do you have those stats?
I don't have that, no, I don't have that specific information. I don't, so I wouldn't want to venture a guess.
Okay, now, I'm not sure if you're going to cover this in your next one. It's not really a statistic, but as far as, what are the penalties like? Does it ever involve termination? Because if so, executives are very difficult to terminate, and owners are impossible to terminate.
Are you asking if the Commission for Human Rights would ever
Yeah, would they ever
award that?
say, like, you got to get this?
We could not. We could not order someone to terminate an employee. I don't believe that we could do that.
So it's usually just moving to a different department or a monetary settlement, things like that?
Damages for pain and suffering, maybe a monetary settlement. If the person that's complaining was terminated, we could award back pay and that type of thing. But I don't know of any precedent that's out there that would allow us in a decision in order to say, as a result of our findings, you need to terminate this employee.
Thank you. Thank you, Madam
Meaning,
Chairman.
I'm assuming you're referring to the respondent, the offending employee.
Yes, exactly.
right.
Like, yeah, I mean, if it happened in my business and someone was complaining about someone, they would be fired that day, not the next day.
Sure, and we do see respondents who take that type of action, but I'm not aware of any commission decision where we've actually ordered that to happen.
Thank you. Thank you, Madam Chairwoman.
Absolutely. Any further questions on the process? Vice Chair McEntee.
Thank you, Madam Chairwoman. As far as the process, first you find the no probable cause, then if they want to request, if the complainant wants to request the right to sue, they can do it after that finding or before?
Well, actually, that's a great question because a complainant, by a separate section of the law, has access to the notice of right to sue that is different from that for both parties after cause. The law is very specific that after a finding of probable cause, we send out the notice, and any party has 20 days from the date they receive that notice to elect to go to court. Under a separate section of the law, a complainant and a complainant alone can request a right to sue after a charge has been with us for at least 120 days, but not more than 2 years. So we often have cases where, for whatever reason, a complainant requests the right to sue to go to court even during the investigation, before the investigation is complete.
So they can do it at any time during the process?
After 120 days. It has to be with us by law for at least 120 days.
Okay, so if they start with the Human Rights Commission, they can't simultaneously have a cause of action in Superior Court for the same sexual harassment that they're alleging in the Human Rights Commission. Is that correct?
Well, technically, they could have a cause of action, but not under the Fair Employment Practices Act, because we would have sole jurisdiction for that first 120 days. They may have an action in court alleging a violation of 42-112, which is the general state civil rights act. They may have an action in court that might be criminal in nature, for example. But in terms of the Fair Employment Practices Act, they would have to start with us and get a right to sue after 120 days to have their claims specifically under that statute that we enforce. But that's not to say they couldn't have another action under another law in court.
Thank you.
Okay, seeing no other questions, please proceed. And I just want to say, I know that this was not easy data for you to access.
It was not.
And I just want to let you know how much I appreciate it, and I know that the numbers will be very impactful and helpful to this commission. So thank you for spending the time and the energy to do so.
No, absolutely. And the reason why one would think that in 2018 it would be fairly easy to cull that data out of the system that we have that tracks cases. The problem that we had, and Representative Tanzi is aware of this, is that our case tracking system is, one, a bit antiquated. We simply don't have the funds to get a more modern one. And two, it's within the control of the EEOC. So what happens is when we tried to cull out that data regarding sexual harassment, there wasn't a way for us to do it independently. We had to reach out to Washington, D.C., to the EEOC EEOC and say, can you run the report and let us know of the charges that were filed in this particular fiscal year, how many of them included an allegation of sexual harassment? The challenge with that was, as you can imagine, and this is what we kept hearing over and over, there is a delay because everyone around the country is reaching out to EEOC to get this data. Every agency like mine, which is a fair employment practice agency, which has a contract with EEOC and uses their system, so they're being flooded with requests for this data, so there is a delay in getting it. Luckily, our requests got in early enough where we were able to at least get some of this information, because as a general matter, we could run a report that tells us how many charges in a given year alleged sex discrimination, and sex harassment is a form of sex discrimination, but we couldn't call out deeper and find out how many of those might have been related to pregnancy, how many of them might have been related to sexual harassment, and what have you. So that is what Representative Tansey is referring to, but we were the proverbial thorn in the side of EEOC to make sure that we got this information in time for this meeting. So I would go on simply to refer to two things. One, we thought that it might be advantageous for you to have a general sense of how many charges we take in a given year, and of those, how many contain an allegation of sex harassment. And I use those words advisedly in terms of contain an allegation, because most often it's the case that a charge filed with the Commission for Human Rights will allege more than one basis of discrimination. So, for example, you could have a charge that alleges disability and age discrimination. You could have a charge that alleges race, color, and ancestral origin. You could have a charge that alleges sex harassment and disability. It's any permutation or any combination. So what we did was we called out those charges that at least included a charge of sexual harassment. And if you look at the handout, and I thought it would be advantageous, again, to give you some context, to have the overall number of charges that we took in. That charge is labeled Rhode Island Commission for Human Rights, that handout, and it says statistics on number and disposition of cases, including an allegation of sexual harassment. And you can see that we were able to get those figures from the EEOC for fiscal years 14, 15, 16, and 17, and we are in the midst of fiscal 18, because as you know, the state fiscal year starts on July 1st. So for example, if you look at you will see that in that year we took in a total of 371 charges. Of those 371, 38, or about 10%, included an allegation of sexual harassment. How many of those are pending or